Okay, want to make sure we stick to our allotted time here for our program called Luncheon Crunch. Want to welcome everybody here. And again, this is going to be a series of programs that you're going to hear from AGC staff in Document Crunch. So with that, I want to turn it over to Joe Hogan from the AGC to do some introductions. Thank you.
Thanks, Brendan. And again, welcome to our inaugural monthly Luncheon Crunch, kind of showing off our partnership with Document Crunch, which, very excited about partnership, as well as about these programs that tie in the kind of things that need to be looked at, paid attention to in the documents. This first one, as advertised, will be about notice, and notice is certainly a big issue. We'll talk about that more in a few moments. But before we get into the program itself, I want to turn this over to Josh Levy of Document Crunch to kind of kick things off, introduce himself, and then Josh Bell introduce himself, and then and talk a little bit about our partnership, and then we'll dive into the program. Josh?
Thanks so much. So yes, I'm Josh Levy. I'm the founder and CEO of Document Crunch. I have not been a tech guy for very long. In fact, I spent my entire career in the construction industry, and I think a lot of you on this webinar today come from an operational background. So I spent my whole career advising project managers, project executives, and other construction industry executives as a construction attorney. Started out in private practice where I represented a lot of big builders for a very prominent construction law firm. But then I went in-house and ran the legal departments for two big general contractors. So I've got a lot of experience around today's topic, notice, but just understand the day-to-day pain that the contract can cause folks in the field. But also similarly, and we'll get into this a little bit more, I also understand why being able to leverage that contract, if you're out there in the field or you manage folks that are out there in the field, why leveraging that contract is really important to keep projects running smoothly, but also just to keep profit in your jobs. Like we all know, this is an industry where we're not making a ton of money every day, and every little bit counts. And oftentimes I've seen in my career, I know Joe's seen it as well, which is kind of at the genesis of why the AGC, New York, and Document Crunch have partnered. I'll talk about that in a minute. But so much of those dollars, which kind of drip out of jobs on a day-to-day basis, is tied up in just mismanagement around the contract. And I think a lot of that actually relates to the topic we're going to talk about today, notice. So I'll kind of come back to the partnership in a minute, but I'll let my colleague Josh Bell also introduce himself.
Thanks, Josh. Yeah, I was before I joined Document Crunch, I was with a top 100 E&R contractor that operates across the southern US and DC. I was actually a former customer of Document Crunch, and I have a similar background as Josh Levy in that I've been in the construction industry, actually on both sides of it. I was on the owner side at one point. So yes, I've primarily been on the contractor side, but have done some on the owner side. So this is a very important topic.
So look, I mean, basically Document Crunch is really all about solving for the really big problem. And the really big problem that our industry faces is that construction contracts suck, for lack of a better way to say. They suck for a lot of reasons, but we're going to be very focused today on why they suck for folks in the field. They suck for folks in the field because it's a pain to administer complex construction contracts day to day. And kind of going back to what I was saying is, while it's a pain and it's hard and it's a time suck, the failure to optimize understanding and leveraging and managing that contract every day leads to problems with change management, fee erosion, wasted time and effort. And frankly, it's my experience having worked on billions of dollars of projects those projects where there's really big problems, often those start as preventable issues where if folks were just well prepared and educated, sitting across the table from one another in the project trailer, some of these issues can be nipped in the bud. But I've seen in my career that there is a disconnect between understanding this stuff and the folks that are out there, making amazing construction progress happen every day. And that's hopefully you all on this call. And so in response to that problem, I founded Document Crunch. I thought there had to be a better way. And at a very high level, what Document Crunch does is it simplifies your ability to navigate and understand construction contracts. It's software that quickly identifies the important provisions that project teams need to know about at the project level. And then it allows you to see where those issues are, to have some context around those issues, and to make better decisions every day. And that's basically what our software does generally. But I'm going to go ahead and stop for a minute and give huge kudos to the AGC of New York, who actually is the first chapter in the country that decided to go a little bit deeper after seeing our basic functionality, which is to say that Joe Hogan and his team have actually curated a project, an AGC New York specific solution, so that when you are now using Document Crunch's software as an AGC New York member, you have the ability to understand issues, which we're going to get into, like notice, and then see what the AGC New York has to say about those issues. And that's an incredibly progressive thing that Joe and his team have done, the AGC of New York have done, to help make you all better, smarter, more prepared, more profitable on a day-to-day basis when you're navigating the contract at the project level. And so we're going to get into this topic of notice today. But again, I just think it's really cool. And frankly, there's been numerous other chapters across the country that are now looking to the AGC New York as an example of how they've really provided value to their members. And so through that partnership, and you can go to the next slide, Joe, through that partnership, we have we've curated this project specific cheat sheet, this project level cheat sheet, which is all AGC New York curated. And members, we can talk about it later, and I think the AGC New York has advertised this quite a bit, but the AGC New York has negotiated really an incredible deal for its members where you can subscribe to this cheat sheet that we're kind of showing you, and we'll walk through how it works with the notices today, where you can subscribe and upload cheat sheets for all of your projects for only $750 a year annually, which Joe and I were actually laughing the other day. It's pretty low when you look at what our published rates for our service are. So just kudos to the AGC New York. And I'm going to now turn this over to Joe and Josh, the two experts, to talk through notice. I guess, yes, one more thing. Here is a QR code if y'all want to just take a minute. If you scan this QR code, it will direct you to a sign up page. We'd be happy to walk you through this AGC New York cheat sheet, show you how this works, engage your interest. I know that in the limited stuff that we've already done, we've got numerous AGC New York members already using this. We're very happy with that. And again, just kudos to Joe and his team for being so progressive and really wanting to make, the AGC New York members better around their construction contract management.
Well, yeah, thanks, Josh. I think one of the things, one of the reasons that we really latch onto this, obviously, the history of AGC doing the spec review service and program, but more importantly, a watchword or watch terminology that we have around here relative to membership is to provide members tools to better manage their business. And I think this is just one more tool that AGC in partnership with Document Crunch is able to offer. So let's get into notice. And before I turn it over to Josh Bell to kind of take the lead on some of the individual clauses and things to be looking for, it's important to put things into perspective about New York State. If the attitude of the courts in New York State, primarily on public work, but I think it's bleeding not just in New York, but around the country. It's starting to bleed into other non-public work. We have private work contracts, quasi-public work contracts, to where the courts are really holding strictly to notice provisions within the contracts. And there are two pieces of it. There's notice of an issue and notice of claim. And what what is bothersome to us, and and I'll be blunt about it, DASNY has one of the most difficult documents as we look at the agencies. There are some that are better than others. They almost appear to be traps in many cases for a contractor to forfeit an otherwise valid claim, valid issue, because they missed something on the notice. I'm even seeing now requirements to notice a claim in documents that I'm reviewing that not only require a simple notice, but almost a perfection of the claim within a very tight time frame. It's also important to note that we have, some special laws in New York. Most are not all that cumbersome, but it goes beyond just what's in the contract document. And the poster child for that is Education Law 3813. So anytime you are doing a school project, the law, not just the contract, I don't know what the contract says, the law says that you have 90 days, 3 months, to provide a notice of claim from the date of accrual. And here's the tricky part. When does that accrue? I've seen cases where accrual of a claim was based on an offhanded comment by the superintendent of schools in a newspaper that they're denying the contractor ability to get paid for something. I've seen it where it's been denied based on a comment in a job meeting that finds its way into the job meeting minutes. So it's important as you think about these things, you think about things that Josh Bell is going to begin talking about, is to think about it in the context of the law and when that accrual is, and be conservative with it. And as we go through this, we'll talk a little bit further about not only the specifics of it, but a little bit of strategy as well in working with your customers. Josh Bell, I'll turn it over to you here to start things off.
Thanks, Joe. Yeah, so I think the overarching point of this is strict compliance with the contract notice provisions. And so we gave a couple of examples here. This is a particular one that says, if you have like a sort of formed kitchen sink notice, it may not comply with the contract, because this one specifically says that there is no damage for the late time, not money. And just to also understand that, and the 2 working days, whether that's practical given the circumstances, we'll talk about later and how that's given, but make sure that you know what your contract says and how the mechanism to comply with that, and just strictly comply with that. And that's where Document Crunch can really help, is identifying that quickly. So project teams, as Josh Levy was saying, can quickly identify that and then comply with the notices. And I would also say, like, there seems to be, in my experience, some hesitancy to send these formal notices. I think that you can kind of soften that with a phone call and just say, hey, I'm sending this because the contract says I have to.
So Joe, before you go into the New York considerations, I just think it's important because, again, I know we're talking to a bunch of operators out there. This basic functionality that you're seeing, where you have this highlighted provision right here, which is a notice provision, that's actually a screenshot of what Document Crunch found in a document, so that you're now able to just click on that cheat sheet that I showed you earlier right through to the notice provisions, and it will take you here. And then the next phase of that is, so great, now you're looking at the notice provision. Well, now Mr. Hogan and the AGC New York actually have something to say about notice provisions, which actually may very well include what Josh just said. Make sure you do a phone call first, but let's see what they have to say, because this is now in the software, which would allow you to just quickly understand, kind of orient yourself around that notice provision and see what the AGC New York has to say.
So this one, this particular one, because it's also within a delayed damage piece, we go into a little bit of case law, Savannah versus City of New York, which has also been used, frankly, as between contractor and subcontractor and prime. And so this is a topic that we'll get into in more depth in a future luncheon crunch. But I think a couple of things that are important to note here with delay damage as we look at the Article 25A of 25A of the OGS form of contract, which was a landmark document or clause that AGC and OGS negotiated together. But there is a pretty detailed notice requirement within that. And it's not so much notice of claim, but notice of the issue. And I've seen OGS, deny any claims on that relative to delay impact based on missing that. And New York City Public Work, for example, has their standard form contract now has provisions to allow for delay damage or impact costs. Their notice provisions are even more strict than OGS, in that not only, and we'll talk about this in more detail later on, not only that notice has to be given once, but it has to be repeated, and there are certain formats that have to be maintained in that. And if you miss one, you may well forfeit your ability to claim. I want to go back for a moment, though, to Josh Bell's comment, and it's one of the things that we often think about relative to notice is there's an important piece of maintaining the relationship between yourself and your client, not wanting to, for lack of a better term, piss them off. And so you think, well, I'm negotiating this. As long as they're still talking to me, I don't have to worry about the formal notice. No, you have to worry about the formal notice. But to Josh's point, and goes to what I deal with in doing partnering on nearly $10 billion worth of construction, manage the expectations. We have a rule: no bad news letters without a phone call first. So if you're going to give notice, you pick up the phone or you go face to face with your client and say, look, I have no choice but to give you this based on the contract. It's just a placeholder, right, to meet the contract requirement, but manage those expectations. I was doing a mediation on a job that almost went off the rails right out of the gate because of 3813 of education law. The contractor, the day before the mediation is going to take place, and it was a voluntary thing, wasn't a contractual requirement, put in the formal notice for 3813. And I got in there talking to the superintendent of schools, and she said, I don't know why I'm going through this. We agreed to do this mediation, and they give me this formal notice. When I explained the law to her, she immediately understood, and the mediation turned out to be very, very successful. It would have been better had the contractor made that phone call and had that conversation ahead of time to avoid that potential problem. Josh, Bill?
Yes, thanks, Joe. To your point about how is a claim defined? And I often see there may be tiers of the claim, like your notice, which can be a really quick trigger before you pull all the information together to say what the claim is. But look at again, strict compliance with the contract. This one says the claim is a demand or assertion of for any adjustment to contract sum or contract time. So make sure you're aware of that stuff. And we'll get into later, as I was talking about earlier, the mechanism for doing that, whether it makes sense, given there's a lot of interplay between these provisions, like where if the owner wants notice of a claim, they have to provide a practical mechanism to do that.
And just note the language in here in 12.1.2. within 7 days after occurrence of the event. Okay, be conservative about that. If there's any question in your mind about when someone might perceive that event to have actually occurred, go with the earlier date. Don't risk, holding up. Well, it really didn't occur till afterwards. I didn't notice it till afterwards, or I didn't fully notice it till afterwards. Be conservative in that regard. And again, strict requirements. Dot all the I's and cross all the T's. Not just on public work, as I said, on private work as well. And you'll see this come up from time to time. Again, with the product, when you see these, you'll see the rationale and insights on this from us. And these are things that will be massaged over time as new information comes in, from New York State, new cases, new insights. We will add to this as necessary.
Yeah, and I think the point is, everyone here has probably attended a webinar or a training where we go through these issues. In fact, Joe and I have given a lecture at the AGC New York conference last December, and I think we're going to be doing it again this December. But what's nice about this, we recognize that you folks out there in the field, you're busy. This isn't your core job. But the reality is this is really an important aspect of you being successful in your job. So we're trying to bring these insights to you in real time. We don't expect that you're going to memorize all of this stuff. We don't expect that you're going to necessarily, go and become, experts like Josh or Joe on these issues. But we do expect that with technology and access to this type of information, that you now have the ability to navigate this more easily and to get the benefit of those insights in real time when you're in the contract.
So adverse weather, Josh Bell.
Yeah, the adverse weather, the reason that we picked this one is the very quick trigger for the notice. It says immediately, but in no case later than 24 hours or you forfeit your claim. And so this was, and we'll get to it later, back to that point about, well, you got to provide a practical mechanism for notifying if you're going to have this type of provision. And oftentimes what I have found is that either from like negotiation fatigue or just not wanting to raise the issue, these things get overlooked a lot of times in the contract. And it's kind of one of those things that never matters until it does. And then all of a sudden you're kind of like, okay, well, I've got to comply with these very impractical notice provisions. So it's kind of that sort of, go ahead and address it on the front end and you'll have better outcomes.
And I understand that, there will be a temptation to be a bit petulant, for lack of a better term. Well, of course, the owner knows we had a massive blizzard with 2 feet of snow. What the hell do I have to give them notice for? They can look at the weather as well as I can. That sounds nice in real time, but later on, not so much. So the strict compliance again becomes critical. So it's just more on the laws. Again, some of our insights and rationale. We'll see this come up from time to time. More on the delays, Josh.
Yes, and before we move on from that adverse weather, the definition of adverse weather is pretty loose. It's like, it says anything that affects the critical path. Well, it doesn't talk about like dry out days or anything like that. So is that an adverse weather delay claim? And then on this one, wanted to highlight this one because it has it's not as prescriptive. It's saying reasonable promptness. Yeah, so to prevent sufficient time for the design builder to provide timely notice. So the reason that we highlighted this one is that it's not as prescriptive, but to Joe's point, like err on the side of providing notice as early as you can.
More on Savannah. So where and how they must be sent. Another important piece. So Josh, I'll let you take that from there.
Yeah, this is a notice provision that says you've got to send, you know, return receipt requested by mail any notices. You know, I always say if it says that you have to show up at the town square on a horse at noon, that's what you got to do. And that's back to that interplay. It's like, well, if you want no more than 24 hours notice of a weather thing, then this doesn't really work because, you know, how are you going to do that?
And this is extremely important. You may have a great relationship with your client, and everything seems to be fine on doing emails back and forth, and they may have even given you a verbal. Oh, well, yeah, you can just give me the email. Well, then change the contract. You know, you got to go back to what the contract says, because you know what? If you get into the formalities of a claim, the lawyers don't really care. Sorry, lawyers, don't care about what was done and the niceties of the project on the project site. They're going to go back to, you did not comply strictly with the contractual requirements. So again, if the owner wants to be more loosey-goosey on this, then make it loosey-goosey in the contract and give me a formal change on that.
Joe, I have to share a war story on this point precisely. So back in the day, I had a contractor that I represented who was working on an elementary school, and the construction was getting a little close to the playground. It was an active school. There was just some renovation work going on. So the principal came out and said, hey, do you all mind, like, we need to reroute like the sidewalk so that when our kids are leaving the playground, they're not too close to your site. There's a safety issue. The contractor gladly complied, did all this change work. I think it was, you know, and the project finished on time, on budget, everything was paid. 2 years later, the project got audited by the school board. And there was actually 3 schools involved. This was one of them, but $2.2 million of work was done pursuant to situations just like that, where the principal of the school was asking for help and the contractor was being a great partner and doing all the work. Well, the auditors didn't see it that way because the formality of the contract wasn't being followed. And so they made a claim and clawed back $2.2 million years after the project was completed on exactly this issue that Josh and Joe were just raising.
Yeah, and Joe, on your point about like the lawyers are going to look, that's absolutely true. That I would look to what the notice provision said, whether I was on the owner side or the general contractor side, because there's often the provision in the very end boilerplate that says like your course of dealing doesn't matter to me, that if you have been doing things by email all along, doesn't matter because the contract says it's not waiving what the contract says.
So a little bit more here on, again, the form and format of it.
Yeah. So on that last one, the reason that we picked that one, because it talks about, there's so many contracts do, like you can send notice by facsimile. And what I would always do during contract negotiations is ask the other side to quickly provide me their fax number. And, you know, no one knowing that they were not going to be able to because no one uses fax machines anymore. So that's back to the whole not being practical. This one is more practical. It's saying you can send notice by email, but you just have to follow it up with a hard copy. And I mean, but just be aware of that second part, that this one says, yeah, it's email. And I've seen it sort of like split out into different types of notice. Like if you're notifying of, say, a weather claim or something like that, email is okay. But a notice of like terminating the contract, the email is not okay. But just be aware of this because, lawyers don't love the email notice, but because of, it's kind of informal. And they don't want to have something come back to them later. And that's why they ask for the hard copy. But talk through with the owner, like the practicality of that. That do you really want, and Joe, to your point, it's like if you don't want to get flooded with paper, then change your contract because you're just complying with what the contract said or what it says. And the whole point back to Joe, to your point about don't deliver bad news without picking up the phone. I mean, that's before you fire off these letters, then these notices say, hey, I'm just doing it because the contract says I have to.
One thing I want to highlight here at the bottom, gives the ability to send it, by email. That's great. There are emails that go out from my office that wind up for some reason in my spam folder. And there's an assumption oftentimes that when we hit send on an email that it's going to be received immediately and understood less of an issue here. But I guess my recommendation here is that do the confirm receipt on the email.
Yeah.
And because just to make sure that somehow or other it didn't get lost in the ether, or you inadvertently typed in the wrong email address. I'd be really careful. Great that they're more liberal here that allows for the email, to be sent, but I'd be extra careful to make sure that you haven't missed a piece on this.
Yeah, and Joe, to your point about the confirm receipt, the way I would get owners comfortable with this is say, confirm the receipt by an actual person versus the automatic delivery notice would constitute notice. That way, the person would have to, there is no like it slipped through the cracks and it went into your spam folder or something like that, because the actual person would have to acknowledge receipt.
And let me and note here up above, right? If it's to the owner, right, or if to the contractor, you actually have a name in there. You're actually looking for the name and the email address that it's going to go to. So one thing to again, this is great to that it allows it for the email. I'd be careful about over copying people. That you want to sometimes if you want to piss someone off, you look at the carbon copies who you've copied on that. So I keep it to the strict piece of this. But I'd also be paying attention to your contact info if the designee of the owner has left. Well, you better get a change to your contract to change that provision to make sure you have the right person in there with that. In the same fashion, if it's got to go to the contractor, who's that going to? And if you make a change, do the formality of it as well, so that something doesn't get missed based on this real, seems like a pretty simple thing, but it can be missed.
Mm-hmm. And also, Joe, to that point, you'll often see in these like with copy to, and I distinctly remember when we were doing a job for a major global organization, and it said with copy to their general counsel. And I'm like, that person has no idea about this project. Do you really want that person to be copied on every notice? Because that's what the contract would say. But yeah, Joe, to your point, like strict compliance, not over compliance, but strict compliance with what the contract says.
So before we go into some Q&A, I want to note that the next Lunch and Crunch will be on October 19th, same time, effectively same station. This one on the New York State prompt payment and retainage issues. And this one, frankly, I may take a little bit more of a lead because in New York State, it's based on a specific law, but it's also, that law also will tie back to contract provisions. So this one will be very, very interesting. The one after that, the following, third Wednesday of the month will be on public work, prompt payment retainage in New York State. And that obviously becomes a real important piece for us. I would also encourage you that, as we are fleshing these out for topics going forward from here, from that third one, if you have any specific requests, if there's something I really would like to see, or I'd like my project manager team to see a program on this part of the contract, please let us know. And we will look to tie those in where we can. And so with that, questions. Brendan, what do we have for questions? Anyone put anything in there?
While we're waiting on some of these to be collected, I would just like say this was the first one of these that we've done, but the intent is to bring as much value as we can. So to Joe's point, topics, or if you have relevant experience and you think you'd be a good panelist, we're looking, to engage and just start a really good discussion, understanding kind of that high level idea that we get it, contracts suck, and we're here to try and help however we can. And that's what we're trying to do with this webinar series.
Okay, well, first question that came up, it just says, where can we access the recording for other people in the office that weren't able to attend? This will be saved, and what we'll do is we'll end up dropping it. We'll send an email reminder out to everyone about the next session. And with that, we'll provide a link for the recording of this session. We'll continue to do that, and we will eventually post them up on the AGC website as well, if you're able to reference that.
Yeah, so you'll be able to not only see the, have the recording, use it, internally in your office, use it for future folks that are coming on board. So yeah, excited about that piece of it.
Other than that, just a comment, great information, great platform.
Thank you.
Nothing additional at this time. I don't know if you see anything else coming through, but again, if anybody does have any questions, you see everybody's contact information up there. Hopefully everybody on the call should, of course, be able to reach out to the AGC staff. You can shoot an email over to Joe Hogan or to myself, and we can certainly, run it by either Josh and go from there.
Looks like we have another one from Marina DeRosa.
Yes.
Which is all Joe here.
Notice time limit, educational, and the cause of action time limit. Well, I gotta go back and reread the 38, the 2B. But I think that the cause of action is just what I found is the time frames. No matter the cause of action. Well, let me back up. Remember, 3813 is not just due to construction contracts. Originally, it was for the citizenry, to give a notice of claim to a school district, maybe they slipped and fell on their sidewalk or something like that. So it's tying in all of those pieces, and it's just been, frankly, I think in somewhat more recent years, been used more regularly in the construction contracts. But Marina, I will look again and reread 3813 2B, see if there's anything more specific there. But as I said before, it's the strict time limits, and the time of when that clock starts ticking is particularly troublesome.
That seems to be it for questions so far. But again, as I said, please feel free to email any of the speakers or any of the agency staff. We can follow up with you as well. So
Yeah, my parting ask is, get yourselves prepared, get yourselves educated. We all collectively have experience knowing that project teams that understand this stuff, the outcomes tend to be better. There's less claims, there's more profit in the jobs, projects run more smoothly, you tend to have happier customers. Take advantage of the opportunity to get yourself educated around these issues and, be the best operators that you can be. This industry can be better. And this is just one small step in that direction.
So we do have another question here.
you want to read it aloud, Joe? So people
Yeah, I'm
have-
having issues with notice of termination, and I'm going to let Josh maybe take the lead on this. We have contacted the owner's rep and client, both verbally and written, as well as certified mail. We are not receiving formal written responses, but rather verbal phone calls. Any idea how to protect us in situations like this?
Yeah, Travis, I guess my question is, are you, maybe you can type this in, but are you the one terminating or are you being terminated? I guess I'll handle either one. We are terminating. Okay. So first of all, it sounds like you're in a situation where you probably now could use to engage a counsel to represent you. Once you've gotten to the point of termination, I think there's a lot of issues that probably are coming up. But to the extent that you continue to correspond the right way and you continue to get verbal, feedback or informal feedback back, I would continue in the meantime to make sure that you are documenting the contents of those discussions and following up, as painful as it may be, recounting those discussions formally. But I would say that, that's just my friendly advice. I would say that, engaging a counsel at this point, if you've already reached the point of termination, certainly would be prudent. And, just do what you can to protect yourself. If you're truly determining that you want to end the relationship, I would not continue to perform if you've got it to that point as well. But again, I think you're at the point where you're pretty far down the road and you probably need a good lawyer to represent you. And happy to, I'm sure Joe knows some folks too, but I'm happy to make a referral if you want to just contact me to a good lawyer in the New York area.
One thing that I want to just, it kind of keys off another issue. I was doing a talk on contract issues with a member and their project managers, and we were going through some contract provisions, and we were talking about notice. And one of the things that I found is that not only was the contractor not paying attention to the notice provisions, but there are notice provisions that are requirements of the owner, and the owner wasn't following their notice provisions either. One of the things I kind of in a smart alecky quip to it. Well, then I guess maybe you're not as damaged by your failure to give notice if the owner's not following it either. But I'm not sure that that's necessarily true. But how do you deal with a situation where the owner is not following his own contractual notice provisions? Josh, any thoughts on that?
Yeah,
Bell, you want to take this one?
yeah, what I would do is just make sure, like I'm complying with everything. If the other party is not, unless it somehow, say, triggers a need for me to provide notice, the notice has to come from the owner first. So in that case, I may say to the owner, hey, when the owner says, hey, where's your notice? I'll be like, hey, where's yours? Because until you do that, if it's a condition precedent or you have to do it first, then I'm not providing anything. But generally speaking, I am going to worry about keeping my house in order. So unless that is going to cause me some operational problems by not getting those notices from the owner, because that is so frustrating that the other side that wants to enforce their contract isn't complying with it themselves. But I would just still keep my nose clean. I would say, okay, well, I'm going to do it regardless of whether you do or not.
Well, thank you. Thank you very much for that. And Josh and Josh, the team at Document Crunch, thank you for this program. As was said, this is our first effort in this regard, and I'm pretty pleased. I think it went very, very well, and I look forward to more of these in the future.
Great.
All right. Very
Thanks.
good. Thank you.
Bye.
Thank you all.
Bye.